we are live. Welcome everybody. Thank you for being here at this bi-weekly legal surgery. I'm here with Alex Woods, a civil litigation solicitor here at Court Wingman. We also have Daria in the background. You might hear from her during this hour. If you don't, then do hit her up at hello@courtwingman.com and she will answer any questions. To start off, we have changed our format a little bit since last week. We've taken aboard your feedback, your struggles with submitting questions, and now we have a form. So you can submit your case via a form that has been pinned in our chat on the right hand side. It is also in every single email that we send out about the legal surgery. So if you do want to appear on the channel, join us on Zoom and hear yourself and maybe see yourself on our channel, then do submit an inquiry. And also if you do want to have an answer to your legal query, do also still submit that form. Because if there's no brave soul out there who wants to be on the channel, we'll just pick a case and then just talk about it as we normally do. So we can kick off with an inquiry that we have received today morning from Matthew.
I'll just say something as a addendum to what you've just said, Kinga, and that is that I think the most constructive way is to have case studies in the surgery, whether it's people who've emailed us in advance or people who are brave enough to join us online, on video rather. You may be worried about confidentiality. Yeah. And I mean, I'll go out there a bit on a limb here. Well, actually, even further on the limb that I'm already out on, because I climbed quite a long way out on the limb already in previous videos. I don't think it's a problem. Providing you're not, I mean, we're talking about civil litigation. We're not talking about criminal law or even family law or children or divorce. I don't see it as a problem. I see it as a positive advantage. I've run cases a lot. I remember having one case and then actually inviting, I think it was the independent journalist came along to cover the case a few years ago. I've never had I was on, what was that show? A daytime TV show. You've been framed.
Rip Off Britain.
Rip Off Britain with Angela Rippon and Gloria Hunniford. They had me on that show a few years ago during the financial mis-selling payment protection insurance scandal. I talked about cases. And, if you're being straight and honest, you've got a genuine dispute, get it out there, get it online, get it aired, get it discussed. You don't have to use names. So what's the problem with discussing your own case online? And even if your opponent, by some very random, highly improbable, eventuality, is on watching, so what? I mean, you're probably only going to reveal to them that you've got a strong case that you feel passionate and determined about. So I think one can overestimate the confidentiality side of things. And anyway, we can just change all the names, and it's an educational role. And I think it's highly unlikely an opponent is ever going to, at court, produce a copy of a Zoom meeting. So don't be shy, be brave, be bold, get it out there. So there you go. And don't forget that we are now closing down Redwood Legal. We're restructuring. We're now offering litigants in person support services through Court Wingman Limited. And we're producing, and Kinga's producing rather, a fresh website called wingman.com with her team, and we really want to make that a place where you can go to and get all the information you need and find out how to instruct us or get free advice or buy a book and all of that. So that will be the portal into the wonderful world of court wingman. Myself and Daria are moving to another law firm where we'll be consultant solicitors, so we'll still be able to handle people who want a full traditional legal representation, and that's South Bank Legal in London.
You made it sound like you're kind of leaving court wingman when you said we're moving to another sister.
Sorry, so as well as setting up Court Wingman Limited, which I think is quite exciting, it's going to be there to a cost-effective way, if for no other reason than VAT isn't added, provide you with advice, assistance, and support where you're litigating on your own. As well as that, at the same time, concurrent, we are going to be solicitors with South Bank Legal. If you come through Court Wingman, you won't have the protections of the regulator. It won't be it's not a law firm at all. Yeah, so you won't have the protections of insurance and the formal complaints to regulator if you get advice from Court Wingman Unlimited. But I don't think that matters because it's litigation, mostly small scale. It's just not a problem in civil litigation. So there it is. I think that's the future. These type of lawyer-like paid citizens advice bureau plus type services to helping people through the civil litigation minefield. We're also increasingly likely, because we're getting work and inquiries, to do personal injury stuff as well. So we'll start to, I think, probably in time, start to include personal injury advice and assistance, perhaps even include them in these legal surgeries, and invite and encourage people with personal injury issues to approach us.
Also, thanks to the fact you're moving away from a law firm setup, we are now able to also do online courses and videos where you could just simply go on the portal and learn about how to deal with your case and kind of win in court without having to pay a solicitor to tell you that. So I suppose thanks to that and COVID, that kind of pushed you forward into changing that structure.
Yeah, and it's kind of a structure that's, I think it's just happening anyway. There are increasing numbers of litigants in person who just simply can't afford a lawyer. It feels like a choice between the Citizens Advice Bureau, who will just give you general advice, and the minute you say, give them details about your case, they say, well, speak to a lawyer. They can only really give you very general advice, which isn't tailored. So there's that, and that's diminishing because, government isn't interested in funding legal services in this country. God bless the last few remaining criminal defence barristers, because that sector's being eliminated. And then at the other end, you've got, the full blue chip legal representation, sign or retainer, £200 an hour, let's get going, taxi meters running. So it's like there's nothing in between. So I want to position ourselves as being able to be the wingman, be the navigator in the aeroplane, be the control tower. Because a lot of times, the more straightforward cases, you can do a lot of it yourself. And then bring in a lawyer, perhaps, if you need to. Have a lawyer go on record if it gets all the way to litigation. But before you issue proceedings, you probably don't want to start paying a lot of money. I've had lots of cases recently where clients have come to us, they've spent like £15,000 on lawyers that have gone round in circles, so it seems to me, for 2, 3, 4, 5 years and never actually even issue proceedings. So...
Well, they do make money from that, don't they? So it's kind of in their interest to run around in circles and use we're trying to solve this dispute in the alternative method kind of line of argument.
I don't think anybody's, deliberately trying to shaft clients. It's just the nature of it is we live in a world where money is everything, isn't it? And every law firm, most law firms, are just geared up to bill, invoice, don't spend more time than you have to on the case, the invoice as high as you can. And it means even conscientious lawyers in law firms just go with the flow, with the corporate flow. And it means, it's interesting. It means that it's actually an advantage to a lawyer to go around in circles, just as you've described. 15 grand before you issue, and then you issue, and then 50 grand go the way to trial. It's a slightly bizarre world.
Well, we could have a whole political argument about the causes and the consequences of our politicians' actions, but we would be here until tomorrow. So let's get on with it. So first question is twofold. It's from Matthew. He emailed us before we started, and his question is, does the money claims online service solely deal with claims regarding civil negligence and civil breach of contract, or can they deal with every conceivable facet of tort in civil law?
Good. We'll answer that one when Daria's back in the office.
Okay. Well,
the short answer is yes. The limits of those portals is more to do with money, size, the value of the claim. There are some exceptions to the types of claim, but it's not so much about tort negligence, no. But let's just park that for the moment.
Okay.
Till Daria's back. Have we got those links that Daria sent through this morning?
Oh, yes, we do.
So I would just put those up so people can, Matthew can have a look at them whilst we're talking about other topics.
Okay, I need to copy them through. Send. Well, whilst I do that, I'll read you another submitted inquiry we have had via the form. So, let's try and brush. Talata, right? But the application.
Oh, finally a question, a legal area I know something about.
Oh, Talata, the application.
Well, I haven't heard the question yet. I've spoken out of turn.
Application is trying to push the property dispute through family court using a child as leverage. House is joint to own, brought 13 years ago, but applicant left over 10 years ago and has never contributed. How was in negative equity? Okay, I was in negative equity when they left, but it's now in positive and they want half. Verbal agreement has always been in place to remove name when in position.
Right, so yeah, good. Thank you very much for putting a proper story out there and proper case study out there. And just in terms of the future and anybody who's watching, don't try and talk about the applicant and so on. That's going to confuse everybody who's listening, confuses me actually. Just talk about the story. You know, my ex, my partner, we're not married, we have a kid. I've been hit with a Talata claim but it's come through the family court system. Is that right? And then there's a kind of a whole separate question around negative equity. She didn't pay a penny, and so on and so forth.
Mm-hmm.
Yeah. So, but I think we can divine what's going on in broad terms in here, and obviously the person in question can. Are we on? I can't see the questions thing, but I guess you've got them, but I don't need to see them. Is that right, Kinga?
I could send them to you if you want to.
No, I'm happy to take my lead from you. You know, when someone pings something. No, fine, carry on as we are. Yeah, you shouldn't be bringing a Talata claim through the family courts. And that's such an interesting question because I don't think family law firms are geared up to deal with Talata claims. I remember having a claim that we were, proper good result for the client. And we represented the lady here on cohabitation property dispute, and he'd instructed a traditional kind of family law firm. It felt like they're doing it on the cheap, like it was sort of legally aided or something, and it didn't any more than I would, go to the family courts to deal with a divorce. Should a family lawyer get involved in cohabitation property disputes, is my view. So now, what about where is the kid involved? You may end up having two separate actions. One, and you may go to the family courts and say, look, this is really, when you have a hearing in the family courts, if she's brought some sort of application to the family courts, you may say, Your Honour, this is really a matter for civil litigation. The substance of this claim is a Talata claim in which she is saying that she owns the house, or she owns 50%, and she doesn't own any of the house. And there's a lot of money tied up in that. So in terms of the kid and maintenance and custody and so on, okay, that's a family matter that we want a family judge to make a ruling on. But as regards to the Talata claim, that's not something that the family courts should be making a ruling on. That's something that should happen in the civil courts. So she may be trying to sneak a Talata claim in through the family courts in order to, use a kid as the pressure, as the sort of the whatever it is, the sort of the blackmail, whatever. But you must be quite clear. If I've understood the facts of this case rightly, if it is, if the main substance of the claim is a dispute over the property, and a secondary issue, at least in financial terms, is the child, you really shouldn't have them going through the same court at the same time. When I handled a case like this, we went through the child maintenance service, and then we threatened to make an application that we never needed to make in the family courts. But we also had an eye on that the main substance of the claim in terms of the share of the property would have gone to the civil courts. Talata is a civil court matter. It should be brought through the civil courts, not the family courts. I think we'd need more detail to talk about the second part of the question. We've got a lot of videos on cohabitation property disputes on the channel. You'll probably be better looking at those in relation to these issues about the equity, who owns what, if they've made contributions or zero contributions, if they're on the title deeds, so on and so forth. It's all out there already. And in fact, I think you've done a playlist, Kinga, of all the cohabitation property dispute videos.
Yeah, there is a playlist on the channel about all of those videos. Another thing we could do, let's say next week, is if we have inquiries coming in throughout the week ready for the live, we could simply invite someone here on Zoom, and they'd be able to answer your questions right there and then.
Yeah.
And talk about it, which I think would be quite an interesting experiment to run, even if it does end up just being an experiment.
Yeah, I mean, I guess that does raise more confidentiality issues because they wouldn't want their partner to be watching while they're talking about it. But I like that idea, and I'm sure there'll be a way to address that problem. But yeah, we've got Daria back. Perhaps we'll go back to Matthew's question, and then maybe this gentleman might give us more information about the nub of the dispute in relation to the property side of his question.
Okay, well, simply, whenever you submit a question via the form, it is editable. So if you go back to it, you'll be able to amend the form, and then I'll receive your amended information on the same page. So essentially, what I'm saying is, do go back to the form and give us more detail so we can come back to it. All right, on to Matthew's question. Do you remember the question, or would you like me to?
Yeah, Daria, we've got a question about does money claims online and civil claims online, two different systems. But let's firstly, what's the difference between them? Civil claims online is a £10,000 limit, isn't it?
That's correct, yeah.
It's a newer, is it a pilot scheme?
I think it's the pilot scheme, yes. looking at this on the civil procedurals, yes, that's correct.
So they've got this. They've got two online ways of making claims online and defending claims online. One has been around longer. It's called money claims online, which a lot of people will be familiar with, and that takes as wide a range of claims as if you did it on paper. Although there are some exceptions, aren't there, Daria? Even for money claims online, there is a list of exceptions.
Yes, that's correct. Yes.
We'll see if we can dig up the exceptions, but we've forwarded Matthew a link. For civil claims online, it's the issue there is simply that the cap is a £10,000 value. Well, I think does money claims online have a financial cap? I think it has 100,000.
It's 100,000. Yes, that's correct.
Actually, this is in the book that I wrote. I've completely forgotten what was in it because we did cover this in the book. Aha! You have been plugged, my friends. Yeah, because we do cover that. I mean, don't expect a lawyer to have every answer in his head on request. Don't trust a lawyer who has every answer in his head upon request. Trust a lawyer who says, I'll go away. I think I know the answer, but I need to check. I'm going to go away and check. Often, the law changes over time, so you do need to be careful. But there is a section. I mean, perhaps have you got this book to hand, Kinga?
Not on me today.
But I don't think it's worth. I could spend 2 minutes skimming it. I might give it to Daria, see if she can find the relevant section, and we can quote chapter and verse.
Okay. Sounds like a plan.
Does that now? His main question is what? Before you do that, Daria, because can you just check online what the limits are in terms of what types of claims can be brought in money claims online and civil claims online? All right, Matthew, you have to hang on. I think we better move on and come back to Matthew again while Daria does the research.
Well, he's got.
This is like one of those TV shows back in the sort of 80s where you were making a cake or something, and they were actually frying up the ingredients and going into the fridge and getting out the ingredients whilst the show was running.
Well, he's got a second part of the question, which I suppose could be answered in a more generic way. Obviously, his question is specific in that he's asking, if this is not the case, what areas of civil law would you need to be redirected to in order to initiate a specific civil law issue? But I guess the general question is, how do you know where to go to start a case?
Put it this way, I don't think when was the last time we had a case where we said, oh, we can't do it in money claims online. Oh, we can't do it in civil claims online.
I don't remember one like that.
Because we've already given you the answer in relation to values: 100,000 money claims online, 10,000 civil claims online. The bigger question though is, can the same types of claims be brought online as it can be brought traditionally by good old Royal Mail?
Well, you wouldn't use Part 8 claims to do civil money claims or money claims online, for example.
You can't do Part 8 through money claims online and civil claims online. Is that what you're saying, Daria?
Yes, you can't.
So for Part 8 claims, there's most claims are what's called Part 7. Civil Procedure Rules, Part 7. Google it. But every now and again you have a Part 8 claim. They're more specialists. So, for example, where you're claiming costs after let's say you've won your case and there's a dispute over costs, you make a Part 8 claim for costs. You also use them in, do you use them in Inheritance Act claims, Daria? We just had one recently, didn't we, where we had to do a Part 8 claim. What case was that? The witness statement.
Yes.
Do you remember the case?
Yes, it's our client. It's our client in Australia.
Ah, yes. Yeah. Don't want to go into the detail of that case, but yeah, there are specialist areas where you have to bring a Part 8 claim. So that Part 8 claims can't be brought online. In terms of other restrictions,
Personal injury, for example, civil money claims online is not for claims for personal injury.
yeah, personal injury can't be brought for civil claims online, but personal injury has its own. Do you bring a personal injury claim through money claims online?
No.
No. So personal injury has a whole separate portal, it's called, and a very specific set of rules that you have to comply with pre-action, and you have to comply with certain personal injury protocols. And there's a whole section of the CPR dealing with that. That's why historically we haven't included personal injury in haven't advertised ourselves as personal injury lawyers. But increasingly we're kind of growing in expertise in that area, so we might start to advertise it more actively. Even though we run some personal injury cases, we don't hold ourselves out as the experts in that area yet. So yeah, you'll find more information in the introduction, online courts. Yeah, so I suggest you buy the book. The introduction section.
You will find the book in various formats on courtwingman.com. So we've got it in separate parts available on Amazon, which are £7.99 each. We've got the paperback and the hardback and the full ebook available on Lulu. All the details can be found on the website. So yeah, enjoy your reading. Okay, on to the next question. It is about identity fraud to do with mortgage. And the question is, would I need a solicitor to follow through?
I already don't like the sound of this. Are you sure we're going to be able to help this gentleman?
It's a lady. Well,
This lady, sorry.
The question is more, it's kind of general, I suppose. In that it's only asking whether she needs a solicitor to follow through with this inquiry and the complaint against the person who committed the identity fraud, or does she just leave it in the hands of the bank?
Yeah, it's an interesting question, isn't it?
Yes.
I find the question invariably, because it's, should I get legal? Should I use a lawyer?
Precisely, it's essentially asking, should I use a solicitor anywhere?
We get a lot of inquiries, and it's like, to be blunt, is there any money in it? Because if there is a lot of money, if you're the Queen and there's been some identity fraud, you've probably got a £1 zillion case against someone. If you're not the Queen, then actually what financial losses have you incurred? If you're a television or film celebrity, and someone is stealing your identity, that you can see how that can have a large amount of damages attached to for reputational damage from someone's identity being fraudulently used. But if it's but you see, that's the critical question in civil litigation. We're not talking about, well, even in defamation, but that's the key question. Has it caused you significant financial loss? And you may want to get law involved simply to help you to answer that question. Ka-ching, legal surgery, £150, 1 hour. But you may be able to answer that question very easily yourself, just by thinking it through. What financial losses have I been occasioned by the banks allowing, or, well, in this case, it sounds as if the banks are investigating it. That's the question. Perhaps this lady can give us further information as to how she thinks she's suffered a financial loss. And at the end of the show, we can give you a little bit more interesting advice.
Well, I do hope she is listening. She emailed us in response to the newsletter that went out. So hopefully, if you're there, Mrs. B, do email us
do. It's such an interesting point because we do get so many people who think I want to get legal, but there's civil litigation is about quantifying your financial losses. It's not about getting justice, fairness, retribution, punishing someone for doing some wrongdoing. The UK, they do have more, in the US, they do have punitive damages, sort of more properly enshrined in law, for example. They don't really have civil litigation, civil law isn't used in that way in the UK. It's usually about quantifying your financial losses.
You said,
and you see,
too.
So please, you think, yes, I've been wronged. The person did this terrible wrong to me, and I'm terribly distressed. But when you drill into it, actually, what have you lost in terms of pounds, shillings, and pence? And if you bring a claim without having properly quantified that, you then get in trouble, particularly against an opponent with deeper pockets, because they could get your claim struck out. So I guess the short answer might be, if there's not a lot of money involved, let the bank do their thing. If you then think the bank haven't properly addressed the issue, and it is a serious issue as far as you're concerned, then appeal the bank's decision to the Financial Ombudsman Service.
They do actually do a good job, the Ombudsman. It takes a while, but they do help you out. But I suppose on the point of it's not about justice, it's about the money, the Ombudsman does take a more this is about justice approach, in that you might get an apology as a response, and that will be enough for them in their view, whilst the court doesn't kind of do those things.
Yeah, you're right. Absolutely, a very good point. The yardstick that the FOS applies is fairness. The yardstick that the court applies isn't fairness, and sometimes it can lead to quite an unfair result. It's interesting because you have in financial mis-selling, you have quite a recent invention of an unfair relationships test, where you've kind of got that yardstick of the FOS drifting into the courtroom, where a judge in certain financial mis-selling cases may face a case where the claimant is arguing he's been that the bank has unfairly treated him, and it's quite a woolly statute. And if the claimant can prove there's unfairness in the relationship, they may be entitled to compensation. But that's like the exception in terms of the court system rather than the rule.
Indeed. Can we go back to the first question, second inquiry we had about Talata? Because Justin has provided us with some more information via the chat.
So Talata, for the uneducated, is cohabitation property disputes, which are quite different mostly, and it can be a variety of things. But in this example, they're most common in cohabitation property disputes where people aren't married, and so a different set of laws apply. It's not family divorce law; it's actually traditional civil law.
And those who are new on watching this, the case is about those rules being used in the family court where they don't usually apply, and the child, according to the person asking the question, is being used as leverage by the other party. Justin has said that there's no issues with the child. Maintenance has always been paid. Childcare is split 50-50, but the mother, who's the applicant, will not be honest to CSA, so they are only aware of old agreement, which is 2 free days per week. Query is, will family court judge understand and resolve this issue using Talata and understand the beneficiary interest, or will they just see the legal position of 50-50 regardless of the circumstances?
I think it's on. If there is no issue about the child, why is the family courts dealing with it? Is this a claim that's listed to be heard in a family court? Has she actually brought? He mentioned the word applicant. Has he actually had served on him a Talata claim that's been issued or filed in the family court? I would think if the family court system had a an N1 claim form which said this is a Talata claim, it would go, oh, no, thank you. We're going to send that over to the civil courts.
Well, he only said that she's trying to push the property dispute through the family court.
Yeah, so it doesn't sound right. And if it should be resisted. Just try and keep it simple. You've got a family court system, specialist judges to deal with children and family matters and divorces. Yeah?
Yeah.
You've got a civil court system to deal with property disputes.
So the courts...
If someone's trying to crowbar a case through the wrong court system, let them try. They might end up on the wrong end of a cost order for wasting the court's time, bringing the claim wrongly or through the wrong court.
That will certainly be good news for Justin if this applicant tried to do that.
There's a big caveat. This is general advice. We don't know the circumstances of this case. It so often turns out when that the story of documents emerge that reveal a whole different complexion.
Or would you like to move on to the next case? Hello, I think Alex's connection has dropped. So we'll just give him a few minutes to reconnect. And whilst he does that, I will try and get through your inquiries and then ask any follow-up questions if there are any. But we have had 4 responses so far for today, not including the email ones. Oh, sorry, Justin, I've just seen you've submitted a second form and I didn't see it when I was reading your chat comments. Okay, but the claim is not issued. Okay, so I suppose Alex's advice still stands. Let me try and get the invitation, try and get Alex back onto the call. Hello?
We had some sort of electrical surge or something in the internet.
Yeah, you randomly dropped.
Yeah.
But I'm glad to have you back. Internet, can't rely on it, can you? Actually, whilst you were gone, I realised that Justin has submitted another response to the original query, and the Talata claim...
It's turning into the Justin show, isn't it?
Talata claim has not been issued, only the E1 form has been submitted.
Yeah, I think that's a claim, and that's a family court claim, isn't it? So yeah. Exactly. So everything we've said is not relevant. Well, it's still right, and people out there listening to it, hopefully that's been helpful.
Yes.
Right, let's move on.
Okay, so another inquiry relates to insurance and liability. So, civil case. If I have an accident in a club that doesn't process my insurance, or if the individual who caused the accident doesn't have insurance, should the club be held liable for not processing the insurance after paying our membership?
Well, let's take it to back to basics. You've got an individual and you've got a club and you've got an accident in the club.
Yep.
So you sue the club because they're most likely to have insurance, even if the individual was responsible, assuming the individual was employed by the club, an agent of the club. And you hope that the club's insurance will pay out for the wrongdoing of their employee who caused you personal injury in their premises.
What if it wasn't an employee?
Then you have to ask yourself the question, is the club, liable in some other way?
Sorry to be.
You can't, as of right, sue a club just because you get injured by a member of the public who's in that club. That would be crazy. I mean, Can you imagine what about a terrorist in a club? You know what I mean? Are you going to sue the club for millions of pounds of compensation for everybody who died during a terrorist attack in a club? No. You can't hold the club liable for a random event of which they had no control just because it occurred on their premises. That would be completely wrong and against the whole principle of the legal system that fault should be there. But if the club has failed to take the duty of care, there might be a negligence claim. So you go back to that lovely old case, what is it? The famous one with the beer bottle. Donahue and Stevenson, yeah. So a club could be negligent. They might have had a duty of care. Perhaps how clubs are paranoid now about handing out plastic glasses. And I guess it's because they've been burnt by people suing them. Well, you shouldn't have had glass in an outdoor area, and I hurt myself. That's a shame, isn't it? How suing everyone left, right, and centre, finding fault with everyone else, and not taking responsibility for the fact that you're completely drunk. But that's the world we live in. So that hopefully answers the question. The club can only be held responsible if in some way they failed in their duty towards providing their duty of care to ensuring the premises were safe.
So was there an electrical a wire on the floor somewhere that someone could easily trip over, or was there a hole in the staircase so you had to kind of avoid it?
Yeah, or if the injury is caused by a glass because the drink was served in glass, let's say, or is that? But that's all pretty simple stuff, isn't it? Is that really the heart of the question here?
Yeah, it appears so. Yeah, I mean, I read it how I received it, so so I suppose so.
Okay, well, we'll get.
Their question was: would the club be liable for not processing the insurance?
I can't understand not processing the insurance. Liable for not processing the insurance. Keep it simple. Are the club liable for the injury caused to you? Have they got an insurance company? Have you written to the club? And, liable for not processing insurance. It's like, not quite sure. You're saying liable because they haven't done some paperwork quickly.
Well, I suppose this is one of the things that, we probably have to address for a bit longer than just a minute when we start this surgery, in that you don't have to really get lawyery and try and talk like a lawyer when answering your questions. Just give us straight facts and then go, what do I do? And this time that will be better than you.
What's the problem? Yeah, what's the problem? The club isn't getting its act together. It's not got its arse in gear. Excuse my French. If that's the case, tell us, because I think this is the problem. The law is simpler than you think.
It really is.
Yeah.
Like, you don't have to think that you know what the right question to ask. Just ask the question and then...
Yeah, just tell us what the issue is. The issue.
let the professional actually pick out where the issue lies, because it's often not where you think it is.
Yeah, and this is a big sell for the book in a way, because, and the principle of the idea of issues, because the problem is not knowing the law or not knowing the law. The problem is not knowing the law. The problem, so much of what I see that comes across our desk is people who haven't identified the issues. You know, and I give a whole section in the book on, if you've identified the issues, I can even see in my mind a court order which the judge has written. I think there's an extract in the book of real life court order. Yeah. The judge is just, you can get so exasperated with a litigating person who just needs to identify what the key issue is. And there'll never be more than one or maybe five max, you know, in priority order. And an issue is, I mean, it's worth a whole legal surgery in its own. Lawyers have trouble getting to the bottom of what the issue is sometimes, because they get so fudged up with the law themselves. But if you can just lay out clearly what the issue is in your particulars of claim or defence, you're streaks ahead. You know, is the issue that the invoice wasn't paid? Is the issue that the work against which the invoice was raised was poorly done? Is the issue that the work was done well, but it was delivered late? You know, those are three different issues. So focus on the issues. Is the issue that it was agreed that the work would be X, and although the work was delivered on time and was great, it was Y? You know, it was the wrong something. I asked for I asked for metal paneling in my flat renovation, and I got wood paneling instead, you know. So focusing on the issues is a case of locking yourself in a room, which you'll already be familiar of if you've been through the coronavirus, and sitting down, isolating yourself, getting out a bit of paper, and actually just taking time out and getting a traditional pen and just looking at the papers, let's say. What are the issues here that you're asking the judge to decide on? And the judge, after the trial, he says, yeah, I find that the work wasn't done to a proper standard. And you've clearly laid out your case built on those issues. And those issues should be in your particulars of claim and your defence. Not a load of evidence, not a lot of other ancillary issues like he was a very angry person and he smashed my, you know, pane of glass in the front door and I want to sue him for that. You know, you get sidetracked by all of those issues. And that's the danger in not identifying what the issues are at the very beginning, is you end up getting sidetracked. Court judges do not have time to sort your issues out for you. If you present a dog's dinner of a set of pleadings, he's got a ton of cases. So you're going to have to do your level best to help him to focus on what's relevant, the key issues in the case.
Indeed. I think that's why they invented strikeout applications.
Yeah, because they do. You can almost see the the big banks lawyers or big corporations. They're just like little wolf. They're like a wolf just behind the street corner, licking their lips, waiting for you to trip up on the pavement. You know, oh, here we go, litigating person going to sue the bank. Come on. The poor litigating person does this huge, great set of pleadings, loads of evidence included as well, and the bank's lawyers are licking their lips because the minute you issue the claim, they make a strikeout application, drag you to court, and you end up, if you're not careful, on the wrong end of the $2,000 or $3,000 costs order before you've even got the plane off the ground, because you've not clearly particularized your claim and identified the issues.
I mean, if we already didn't
in a bank claim, sorry to interrupt, but in a bank claim, you've also got complexity. You've got to bring a claim under, the unfair relationships test, or whatever it might be.
Same with policing, etc. When you try and
Police cases as well. Don't bring it on your own. Find a lawyer. Goodness gracious, yeah. Well, yeah, no. you need legal advice for financial mis-selling and police prosecutions. Definitely.
I mean, if by now we haven't sold you the very wonderful book that Alex and our team have written, do at least read the free chapter, which kind of gives you a nice summary introduction into the court system and kind of knock down all the misconceptions that you may have had about what the court is. It will help you to get your head in the right space, I suppose. Alex,
Yeah.
are you searching something in the book?
No, I just know that so much of what it feels like the Flying Solo plug show, doesn't it, today? But there is so much of what I'm talking about is in here. But and it'd be better to talk about yeah, that's all I'm thinking. But I don't want to be a big plugger. So what have we got? Any more?
Yes, well, the next one is in criminal law. I know you did criminal law in the past a while ago. So do you want to deal with some
I think only if there's no one else who's got civil law inquiry, because the thing is we have advertised this and we are civil litigation specialists, so we should deal with any civil litigation matters.
Okay, well, the only thing I have is a follow-up from the liability claim to do with the club.
Oh yeah.
Okay, so Andrew, I really do hope you've written this in the way that I can just read it out loud and not be confused. Following up on my liability claim question, I was climbing in a club and one of the members, former club president, didn't set the rope correctly and I fell. They were made aware I had no climbing experience prior to the trip. They claim the club was not responsible as it was not a club trip. However, there is nothing in writing to suggest what a club trip is, and I was never informed it wasn't a club trip. Talking about the insurance, I was meant to have club insurance paid for with my membership, which would have covered it. However, even though the club told me it was processed, it never was. This trip was organised in a club group chat and planned by the current president. Club gear was used and he admitted liability, but has since gone back on his statement.
Value of claim?
Huh?
What's the injury? How serious? Did he say?
He did not. He said it's complicated, but we'll provide more info in the next session.
Well,
that's an unfortunate event. I hope you're okay.
Yeah, and it does start now to feel like a bit more of a genuine claim. Thank you for actually providing the nuts and bolts detail. That's a very good case study for our legal surgery, because it raises so many interesting, if you're a lawyer, interesting issues. The starting point should always be keep it simple. If you've been, I mean, this is actually in the club. Apparently, this accident occurred. It didn't occur outside, did it? It said it was actually in the club. So we're talking about a climbing club, not a nightclub.
Yes, yes.
And the really critical issue here, you almost don't need to know talking about insurance and everything else and admissions, was that rope, is it the practice of the club to routinely make sure that when students are in their care, paying students are in their care, is it common practice to make sure all the ropes are secured? Well, obviously, it kind of goes without saying in a climbing club, doesn't it? Mm-hmm. So if you can demonstrate that there was some negligence, then everything else becomes a secondary battle that you will probably win, probably, you know, because I guess that's one of the beauties of the legal system in England and Wales is sometimes it's very vague, but it's often very vague because it doesn't want to be prescriptive and say, well, if there's not insurance in place, you can't be liable, or it's not top-down law. It will tend to try and, you know, do the right, just thing. It obviously matters how serious the injury was as to whether or not to what extent you want to take it further forward. And if it's a personal injury claim, the limits have changed such that, I think the limits have changed in respect of road traffic, but I think also in other personal injury claims as well, such that it may be quite a critical question what the likely value of the claim is, how serious the injury is. Because if it's not serious enough, you'd have to run it yourself now. If it is more serious, then you'd be able to get probably a no-win, no-fee lawyer to help you with the claim. It's the club, isn't it? Even if for some reason insurance wasn't in place, you can still sue the business.
Well, they didn't process the insurance, even though they said they have. So I suppose if...
Well, it sounds as if he's been given the runaround, isn't he? A little bit. And because they know he's not got lawyers, he's been given the runaround. They probably, because he's mentioned that they admitted liability, didn't he?
The former president has, and then he
went. I mean, they're not. Sadly, people aren't. Aren't going to just say, "Oh, we're terribly sorry. Here's a bunch of money. We were wrong." And it's a sad state of affairs in a way, because we live in a world where businesses don't do that because they're afraid that it will open up the door to everybody else to say, well, I got a scratch last week, can I have some money too? So sadly, the club's lawyers will be saying to the club, no, don't do the normal, healthy, natural human thing. You've got to deny it. And make life difficult. And that might have happened here. And at the end of the day, the club might be in financial difficulty. He doesn't want to start bailing out money. It's just going to make your life difficult, so it'll come up with excuses. You've got maybe this is a case, if it's not too serious, you issue it yourself. Maybe we could, you pay us a little bit of money, we could help you on the person, we could help evolve this personal injury advice and assistance that we're thinking of giving in the future by using this as a case study. Worth thinking about.
That is an idea. Well, you kind of finish at the perfect point because it is 1 p.m. We didn't have time for one question, which was really in criminal law.
Was it a simple question or was it quite a big issue?
Oh no, it was really a set of facts. So someone was driving, had one too many beers, was driving with friends, fell out of the road into a lamppost at a roundabout. The police were called. They breathalyzed him. He was at 40. And well, what was he to expect in court?
Yeah, I actually can't help you. It's 15 years since I did criminal law. I don't know.
Oh, I suppose.
You need to find, do we know anybody who knows? There is one, you can always email, because we do have a criminal lawyer in London who refers us civil work when she's got it, and we refer her criminal work if it comes our way. So you could always email us at Court Wingman. We could send you in the direction of a criminal lawyer.
And as to everyone else who has sent an inquiry or was just watching, wondering whether we're worth your pounds and pennies, if you do have an inquiry and need some help, like a 1-hour legal surgery or a preliminary review of your case, which usually takes between 3 to 5 hours of solicitor's time, then do email at hello@courtwingman.com. If you can't afford legal advice right now, but need knowledge, then do check out the book Flying Solo: How to Represent Yourself in Court in 2021. You will find the information about the book and where to purchase it on our website again, and you can download a free chapter at book.courtwingman.com. Obviously, our contact details are just below and all over the channel, social media and Google. Do hit the subscribe button, do hit like, do leave a comment, because it does help us reach more people on YouTube. More people like you who need some legal assistance and simply don't know that we exist. Thank you.
And to be clear, Court Wingman, separate company, not regulated by the SRA. Think of it as Citizens Advice Bureau Plus, but you don't have the protections that you would have if you had any complaints about the service. You couldn't go to the SRA or so on. There's not insurance to cover you for, but it's meant to be more, I don't know, think of a word, Kinga.
What you're describing really would apply to a massive case if someone had full legal representation, because you can't really mess up a lot in an hour legal surgery.
No, but you can. But also we could draft your particulars of claim. But the point is, you get a law firm to draft your particulars of claim. If they get it wrong, you can go after the law firm, complain, and so on. You're not getting the same level of protections through Court Wingman Limited. But my belief is that the lower value claims, civil and simpler claims, civil litigation claims often are, you don't really care about, you don't want to pay the extra premium to get the protections if you were to go through a law firm just to draft particulars to give you a 1 hour's advice. You'd rather go to Court Wingman and be done with it in terms of the protections. But we also do work as consultant solicitors with South Bank Legal. So if you wanted to pay us more and instruct us formally as traditional lawyers, we can go that route too. But this video is aimed at Court Wingman. I just mentioned the fact that we're working as solicitors, as consultant solicitors for another law firm in passing.
Well, you're being very transparent, and there's a lot of
trying to. Yeah, you got to be careful these day and age.
You do indeed. Anyways, thank you so much. Thank you for your inquiries, for being here, for following us and hitting that subscribe button. Thank you so much, and see you soon.
Thank you, Kinga. Thanks for hosting it today. Bye.
Bye-bye.